Welcome. It is very good to have you here. If you have found your way to this channel for the first time tonight, then I hope you will stay a while and perhaps subscribe if you find the stories restful. We are building something quiet here, one old case at a time, and every new listener makes it a little warmer. For those of you who have been here before, thank you for coming back. I do love to know where in the world people are listening from, and what time of day it is for you. Are you tucked in for the night somewhere in England, or perhaps drifting off in a flat in Berlin, or making a morning cup of tea in Melbourne, and letting this wash over you before the day begins? Drop a comment below and let me know. It matters more than you might think. Tonight's story involves a man who had what we might call a rather more complicated day than most. His name was Rochford Fitzgerald. He was the sort of man who moved through Georgian London in the way that a certain kind of person always has, relying on charm and connections and the good faith of people who ought perhaps to have known better. And in the early weeks of 1738, he found himself at the centre of a forgery charge that could, had things gone differently, have cost him his life. The irony, which you will come to appreciate in time, is that tonight's story ends not with a guilty verdict, but with an acquittal. Rochford Fitzgerald walked out of the court a free man. Whether his day was a better one than most, or simply a very long and anxious one with a welcome ending, I leave for you to decide. Now, let your shoulders settle. Let your breathing slow. We are going somewhere far from here, somewhere dark and old and very quiet. The city of London, in the year 1740. Let us begin. Imagine the city at night. Not the London you might picture from photographs or films, not the city of electric light and the distant rumble of engines, but something older and stranger and very much darker. The London of 1740 was a city that went to bed early, not from choice but from necessity. Candles were expensive. Rush lights burned poorly and smelled of animal fat. When the sun went down over the rooftops of the city, and the last of the natural light bled away from the sky above the Thames, the streets did not light up. They grew very dark indeed. There were oil lamps. The parish vestries of many of the city's wards had taken it upon themselves to hang lanterns at intervals along the main thoroughfares, and their flickering yellow pools of light did something to make the streets passable after dark. But beyond the main roads, in the courts and alleys and the narrow passages between houses, the darkness was very nearly complete. The watchmen who patrolled these streets carried lanterns of their own, and the sound of their footsteps and their occasional hoarse call of the hour was one of the characteristic sounds of the Georgian city at night. That, and the rattling of coaches over cobblestones, and the distant noise of a tavern door opening and closing, and the sound of the river. The Thames was always there. Even in the deepest parts of the city, far from the water itself, the river made its presence felt. In the winter months, the smell of it came in with the fog that rolled off the water and settled over the city in layers, cold and damp, and carrying that particular mixture of wood smoke and coal smoke, and the smell of mud and commerce and slow decay that was the smell of Georgian London. If you stood on any of the city's bridges at night and looked east toward the Pool of London, you could see the shapes of ships riding at anchor, their lanterns reflected in the black water below. It was a city that lived by the river and smelled of it and thought of it constantly, even when the water itself was nowhere to be seen. The winter of 1739 into 1740 was a particularly harsh one. This is not a literary flourish, but a matter of record. The decades around the middle of the 18th century in England were marked by a series of exceptionally cold winters, years when the Thames itself froze solid enough for frost fairs to be held on the ice, when the streets of the city became treacherous with packed snow, when the poor died of cold in their garrets and cellars in numbers that the parish registers recorded with quiet efficiency. The winter of 1739 was one of the worst. By the time the spring sessions of the Old Bailey convened in May of 1740, the memory of the cold was still very much with the people of London. It is May now, though. The worst of it is over. The evenings are growing lighter and warmer, and the city is coming back to life after the long contraction of winter. The market gardens to the north of the city are beginning to produce again. The Thames is open and busy with river traffic. In the parks and pleasure gardens, the fashionable are beginning to think about their summer entertainments. But in the law courts of the Old Bailey, the work of justice proceeds regardless of the season, and tonight's story takes us back even further than May of 1740. It takes us back to a cold morning in February of 1738, and to a piece of paper that changed a good many things, and ultimately, for one man at least, changed very little. The street outside the court is already busy. The Old Bailey stood, as it stands now, though in a very different form, at the western edge of the old walled city, hard against the old Newgate prison whose shadow fell across the proceedings, like a permanent reminder of what the law could do to a man. Newgate was not a pleasant place to wait. It smelled of sickness and damp straw, and the accumulated misery of many thousands of people who had passed through it over the centuries. Its walls were thick and very old, and the sounds from within it did not encourage calm reflection. But on a May morning in 1740, with the light coming pale and clean over the rooftops and the sound of the city's business beginning to fill the streets, even the shadow of Newgate could not entirely suppress the faint sense of a world waking up and going about its ordinary life. Inside the court, the candles are lit. The judges are arranging themselves on the bench. The barristers are pulling on their wigs and settling their gowns around them. The clerk is shuffling papers. The jury, 12 men of the city, are finding their seats and preparing to listen. And somewhere in the building, in one of the holding rooms or passages that connected the court to the prison next door, Rochford Fitzgerald is waiting to be called. He has been waiting for rather a long time. The charge against him was laid in February of 1738. It is now May of 1740. That is 2 years and 3 months in which the threat of this prosecution has hung over him. 2 years in which he has been abroad to France and come back again. 2 years in which he has continued to move through the coffee houses and taverns and counting houses of London, with the particular mixture of confidence and anxiety that characterizes a man who knows a warrant has been taken out against him and is not entirely certain when it will be executed. He is a complicated man, Rochford Fitzgerald. You will come to see that in time. But before we enter the court and hear what the witnesses had to say, let us spend a little time in the world that produced him, and in the world through which this story moved. To understand what happened to Rochford Fitzgerald, you need to understand something about the way money moved through Georgian London. In the 21st century, when we pay for things, we mostly do so at a distance, through systems of electronic transfer that are invisible and instant and take place without any physical object changing hands. In 1738, money was an altogether more physical thing, and its movement from one hand to another required a network of paper instruments, personal trust, and face-to-face relationships that strikes the modern reader as both remarkably sophisticated and remarkably fragile. The instrument at the heart of tonight's story was what the court called an order for the payment of money, a bank draft. These were documents of enormous practical importance in Georgian commercial life. The principle was simple enough. If a merchant or a gentleman of means had funds deposited with a banking house, he could authorize that banking house to pay a specified sum to a named recipient or to the bearer of the document by signing a draft in a particular form. The recipient could then present the draft to the bank, who would verify that the signatory had sufficient funds and pay out the money accordingly. This system worked, when it worked, because of the trust that underpinned it. The banks knew their clients' signatures. A client's credit was his reputation, built up over years of dealings, and a man's name on a piece of paper carried weight precisely because it carried the full weight of his commercial standing. To forge a man's name to such a document was therefore not merely a financial crime, but something closer to an identity theft, a seizure of another man's creditworthiness for one's own use. The cheque-books issued by banking houses in this period were sometimes literally that, books of paper printed or specially marked in a recognizable pattern, the checked paper that appears in the testimony tonight. This distinctive paper served as a kind of authentication, a signal that the document had originated with the banking house's own materials and not been fabricated from scratch. The pattern of the paper was meant to be difficult to counterfeit, and a banker who knew his customer's business could often tell at a glance whether a draft presented for payment was genuine or not. Mr. Shuttleworth, one of the bankers in tonight's story, tells us precisely this, that he knew at once the draft was not his client's hand. That instinct, that readiness to look closely at what was presented to him, saved his firm £12 and 10 shillings on the morning of the 1st of February, 1738. The statute that made forgery a capital felony in England had been strengthened repeatedly over the course of the 17th and early 18th centuries, as the use of paper instruments in commerce had grown and the opportunities for fraud had multiplied with them. By 1740, forgery was a hanging offence, not a transportable offence, not an offence for which you might be branded or whipped and sent home chastened. A felony for which, if convicted, you would be taken to the place of execution and hanged by the neck until dead. The law made no distinction between forging a bond for £10,000 and forging a draft for £12 and 10 shillings. The crime was the same, and the punishment was the same. This is the shadow that falls over Rochford Fitzgerald as he waits to be called. He is not charged with a minor matter. He is not facing a fine or a few months in one of the city's houses of correction. He is standing at the bar of the Old Bailey, charged with an offence for which the law of England prescribed death, and the fact that the draft in question was for a relatively modest sum made no legal difference whatsoever to his situation. Forgery prosecutions in the 18th century were taken with the utmost seriousness by the courts, and they were also, by the standards of the time, relatively sophisticated affairs. Because the crime was so often a matter of handwriting, and because the authenticity of a signature was a question that could not always be resolved by the untrained eye, forgery trials frequently involved a kind of proto-forensic examination of documents, with witnesses being asked to compare handwriting samples and give their opinion on whether a particular piece of writing was or was not in a particular man's hand. The courts were well aware that such evidence was subjective, and the common law had developed a body of practice around how it should be treated and how juries should be directed to weigh it. Tonight's trial includes a good deal of this kind of evidence, and the way the witnesses describe their examination of the disputed note, comparing it letter by letter with known samples of the defendant's writing, gives a vivid picture of how such investigations were conducted in a period before photography, before forensic science, before any of the technical apparatus we now take for granted. There is another strand of the law that makes an appearance in tonight's proceedings, one that is easy to overlook but very important. The question of who could give evidence at all. Under the rules of evidence that applied in English courts in the 18th century, a witness who had a direct financial interest in the outcome of a case could not give evidence in that case. The logic was straightforward enough. Such a witness could not be expected to be impartial, and the law would not compel the jury to trust testimony that was tainted by self-interest. Tonight, you will hear the court apply this rule in a particularly interesting way. When the man whose name appeared on the forged draft is called as a witness and promptly disqualified by the court on the grounds that he is listed as one of the intended victims of the fraud. It is a moment that tells us a great deal about how the courts of the period thought about evidence and interest, and the relationship between the two. But we are getting ahead of ourselves. Let us go back further still, to the world in which Rochford Fitzgerald moved, and the people he knew. Rochford Fitzgerald was a man of uncertain occupation and definite social aspiration. The picture that emerges from the testimony given at his trial is that of a man who occupied the fringes of Georgian respectability, a man who had connections in the better sort of company, but who moved through it with the particular anxiety of someone whose grip on that world was not entirely secure. He drank Frontignac wine, which was a fashionable and expensive sweet wine from the south of France, the sort of thing that men of quality drank when they wished to signal their refinement. He attended masquerades, those elaborate public entertainments at which Georgian Londoners of the upper and middling sort paid good money to dress in costume and move through candle-lit pleasure gardens, pretending for an evening to be someone else. He had acquaintances among wine merchants and men of business. He knew how a counting house worked and what a bank draft looked like. He was, in short, a man of the town in the particular 18th century sense of that phrase, which is to say, a man who had made the social geography of London his professional environment, who lived by his wits and his contacts and his ability to present himself as a person of consequence. He was also, by the evidence of those who knew him, a man who played cards. Several of the character witnesses who appeared at his trial mentioned gaming, and not always approvingly. One witness said that since the defendant had given up business for a pleasurable life, he had been a gamester. Another said he had heard the defendant called a gamester and a sharper, which is a rather stronger thing to say. Sharper being the 18th century term for someone who cheated at cards. Whether the defendant was genuinely dishonest in his gambling or merely unlucky in his acquaintances is one of those questions the trial record does not resolve. He appears to have had some connection to Ireland, as his name suggests, and he had dealings with a man called Lutterell, a merchant or man of business whose cheque account with the banking house of Knight and Shuttleworth was at the centre of the whole affair. The relationship between Fitzgerald and Lutterell was a complicated one. Fitzgerald appears to have been on intimate terms with Lutterell's household. He had married, or at any rate was closely associated with, one of Lutterell's family. He was frequently at Lutterell's house. He was, as he put it himself in his defence, conversant in his counting house and in his business. He had seen Lutterell's letters. He knew how Lutterell's drafts were drawn, what paper they were written on, how they were worded, and to whom they were addressed. All of which meant that when Rochford Fitzgerald found himself arrested for a debt of 6 guineas on a December morning, and in need of bail, and in possession of a piece of checked paper from Lutterell's counting house, the temptation must have been very considerable indeed. The parish of St. Martin in the Fields, where Fitzgerald lived, was one of the most densely populated and socially varied districts of Georgian London. It stretched from the Strand northward through Charing Cross and St. Martin's Lane, and the streets around what is now Trafalgar Square. A district that in 1738 was still a relatively open space with the King's Mews, occupying much of the ground to the north of Charing Cross. To the west lay the fashionable streets of St. James's, where the aristocracy and the gentry maintained their London houses and their clubs. To the east lay the bustle of Covent Garden and the courts of Chancery Lane. Suffolk Street, where Patrick Cannon ran his tavern at the sign of the Cannon, was a short street running south from Pall Mall, a street of respectable lodging-houses and small businesses, exactly the kind of address at which a man like Fitzgerald might be expected to take his ease. The tavern, or victualling house, was the social institution of Georgian London in a way that has no precise modern equivalent. It was at once a place of business and a place of leisure, a venue for the signing of contracts and the settling of debts, for the consumption of food and drink, for the exchange of news and gossip, and the conducting of all manner of personal and commercial affairs. When Rochford Fitzgerald was arrested and needed a bail bondsman, it was to a tavern that the bailiffs brought him, or rather to the house of a man he knew who kept a tavern, a man with whom he had drunk wine and played cards, and conducted the ordinary business of acquaintanceship over what sounds like a period of several years. Patrick Cannon, the vintner of Suffolk Street, is one of the more sympathetic figures in tonight's story, though the portrait that emerges of him is not entirely without ambiguity. He was a man who kept a respectable house, who had his wife's opinion to consider when asked to do favours for people who had not always treated him well, who had been bail for Fitzgerald before, and had paid the money when the defendant had failed to honour his obligations. He was, in other words, a man who had learned from experience to be cautious about Rochford Fitzgerald, and who nevertheless found himself, on that December morning, agreeing to bail him again. The banking house of Knight and Shuttleworth occupied premises in Change Alley, which lay off Cornhill in the heart of the old commercial city. Change Alley was famous throughout the period as the centre of London's financial speculation, the street from which the great bubble of the South Sea Company had radiated its promises and then its catastrophe in 1720, and which had remained after the bubble burst as the address of coffee houses and insurance offices and smaller banking operations that clustered around the Royal Exchange on Cornhill. Knight and Shuttleworth were bankers in the sense that they held deposits and made payments on behalf of their clients, one of dozens of such firms that operated in the City of London in this period, providing the credit and the payment services on which commercial life depended. Robinson Knight, the senior partner whose name appeared in the firm's title and whose name appeared in the title of tonight's case, was the man whose interests the prosecution nominally represented, though, as you will hear, it was his partner Edward Shuttleworth who played the more active role in the events of February 1738. Shuttleworth was the man who had received the forged draught when Cannon brought it in for acceptance. Shuttleworth was the man who had recognised immediately that the signature was not his client's. Shuttleworth was the man who had sent for Lutterell to confirm what his own judgment had already told him. And Shuttleworth was the man who had caused Cannon to be detained and brought before the Lord Mayor. The Lord Mayor of London had a particular role in the criminal justice of the city that is worth pausing to explain. In addition to his ceremonial functions, the Lord Mayor sat as a justice of the peace for the City of London, and in this capacity he received depositions, issued warrants, and conducted preliminary examinations of persons brought before him on suspicion of criminal offences. It was to the Lord Mayor that Cannon was brought after his unfortunate visit to the bankers in Change Alley, and it was the Lord Mayor's examination that established the outlines of the case against Fitzgerald, led eventually to the taking out of a warrant for his arrest, and thus set in motion the 2-year process that brought the whole affair to the Old Bailey in May of 1740. 2 years is a long time for a case to make its way through the system, even by the relatively unhurried standards of Georgian criminal justice. Part of the delay, as we shall hear, was caused by the fact that Fitzgerald himself was not immediately available to be arrested. He had, as the prosecution witnesses described it, fled. The defendant himself had a rather different account of his departure for France, involving a debt of £157 to be recovered at Dunkirk, and a woman with whom he had been living, whose friends and family were displeased with the arrangement and the general convenience of being abroad while a warrant was being sought against him. Whether this amounts to flight is a question the jury would eventually have to consider, along with all the other questions the case raised. Let us now enter the court itself, and let the proceedings begin. The Old Bailey that Rochford Fitzgerald entered in May of 1740 was not the imposing neo-classical building that stands on the site today. The present Central Criminal Court was not built until the early 20th century. The court that heard this case was an older and rather more informal structure, a building that had been reconstructed and enlarged several times over the preceding century, but which retained something of the rough practicality of its origins. It stood, as now, at the junction of the Old Bailey and Newgate Street, immediately adjacent to Newgate Prison, and the physical connection between the court and the prison was a literal one. Prisoners were brought directly from their cells in Newgate through passages and corridors into the court building, and convicted felons awaiting sentence or execution remained in the prison's care. The most distinctive feature of the old court was that it was open on one side. The proceedings took place in a room that was open to the street along one of its walls, which meant that air could circulate through the space, and that the public could observe the proceedings from outside as well as from the gallery within. This arrangement had been arrived at not from any desire to promote transparency in the administration of justice, though that may have been a secondary benefit, but from a very practical concern about the health of everyone who spent time in the building. The jail fever, which we would now call typhus, had several times swept through the Old Bailey and Newgate, killing not only prisoners but judges, barristers and jurors. The open-sided court was an attempt to prevent the spread of disease by ensuring a constant movement of air, and it had the incidental effect of making the Old Bailey one of the more publicly accessible law courts in the country. The judges who presided at Old Bailey sessions were a mixture of common law judges sitting on circuit, the Recorder of London, and the aldermen of the city who took their turns on the bench. The proceedings were conducted with considerable formality, the judges in their wigs and robes, the barristers similarly attired, the clerk of the court managing the flow of business with the efficiency of a man who had done it many times before. The jury sat in their box to one side of the court, 12 men of the city or the county of Middlesex, depending on where the offence was alleged to have been committed, who were expected to listen carefully to the evidence and return a verdict on the spot at the conclusion of the case. There were no opening speeches from the defence in the modern sense. The prisoner was not represented in the same way that a defendant is represented today. A barrister might appear on behalf of the prosecution, presenting the case and examining the witnesses for the Crown. The defendant could have legal assistance in limited ways, particularly in cross-examining witnesses and in raising points of law. But the main burden of defending oneself fell on the defendant personally. The speech that Rochford Fitzgerald gave at the conclusion of the prosecution's evidence in tonight's case is his own voice, his own account of events in his own words, and whatever one thinks of the truth of what he says, it is a remarkably composed and detailed performance for a man standing in the dock of the Old Bailey on a capital charge. The atmosphere of the court on a busy sessions day was not the hushed and reverential thing that we might associate with a modern courtroom. People came and went. Witnesses waited in corridors and anterooms. Spectators watched from the gallery and from the open side of the building. Business was conducted at considerable speed by modern standards, several cases often being heard in a single day, and the formalities, though real, were not so elaborate as to slow proceedings to a crawl. There was, nonetheless, a weight to what happened in this room, a gravity that everyone present understood. This was a place where men and women could be condemned to death. The candles burning in their holders along the walls, the smell of the tallow and the wood of the benches and the old stone of the building, the faces of the judges looking down from the bench, all of it combined to produce an atmosphere that no one who had been in it was likely to forget. Rochford Fitzgerald stood at the bar and heard the charges read against him. The indictment was lengthy, as forgery indictments typically were, because the prosecution was required to set out not merely what the defendant was accused of doing, but the precise legal basis for the charge, including the specific intent alleged. Fitzgerald was charged, in the first count, with having feloniously made and forged a certain false and counterfeit order for the payment of money. In further counts, he was charged with having uttered and published the same, knowing it to be false and counterfeit, with intent to defraud the bankers Robinson Knight and Edward Shuttleworth. And in additional counts he was charged with the same acts committed with intent to defraud Patrick Cannon, the vintner of Suffolk Street. The note itself, as read into evidence, ran as follows. London, 27th of December, 1738. Messieurs Knight and Shuttleworth, pay Mr. Rochford Fitzgerald, or bearer, 14 days after date, £12 10 shillings. L. 12. 10. Nothing. For Richard Lutterell and Company. Change Alley. It is worth pausing on this document for a moment, because it tells us several things about the man who wrote it. The form is correct. Fitzgerald knew how such drafts were worded, what information they needed to contain, what the layout should look like. He used checked paper, the distinctive paper associated with Lutterell's account with the bankers. He made the note payable not immediately, but 14 days after date, which was a common enough term in commercial instruments, and gave the whole thing the appearance of a genuine business transaction rather than a hasty fabrication. He named himself as the payee, which was bold, but perhaps less suspicious than naming a stranger. And he added the words and company to Lutterell's name, which he later claimed was a deliberate precaution, a way of signalling that the instrument was not quite what it appeared to be, that he had introduced a small error to prevent the note from being mistaken for a genuine draft if it fell into the wrong hands. Whether this explanation was true, whether Fitzgerald had genuinely intended the note as a private piece of paper rather than a negotiable instrument, is one of the central questions the jury had to resolve. And it is not, when you look carefully at all the evidence, an entirely implausible story. The counsel for the prosecution having opened the indictment and explained the nature of the offence to the court, the witnesses were called in turn. The first to take the stand was the man whose name appeared on the back of the disputed note. The man who had carried it into the banker's and set the whole unfortunate chain of events in motion. His name was Patrick Cannon. Patrick Cannon was, as we have already established, a vintner. He kept a house at the sign of the Cannon in Suffolk Street, a name that may or may not have been a coincidence of the kind that the age found delightful, and that we might now find a little too neat. He was a man who knew Rochford Fitzgerald, who had done business with him and drunk wine with him, and on at least one previous occasion found himself standing bail for him, an experience that had not ended happily. He was called to give the first and, in many respects, the most important evidence in the case, because he was the man who had received the note from Fitzgerald's own hands, and it was his account of how and why he had received it that would set the terms for everything that followed. He came to the stand and faced the court, and what he told them was this. "I know this paper," Cannon said. "It is a draught on Knight and Shuttleworth. I had it for a security, and I was taken up last New Year's Day was 12 months, on account of this note, at Messrs. Knight and Shuttleworth's in Change Alley. I went thither to get the note accepted, and tendered it to Mr. Shuttleworth himself. He desired me to stay a little, and told me he thought Mr. Lutterell was not then a trader in company. But he said he would send for him, and accordingly he did, and asked him if the name Richard Lutterell and Company was his hand. He told him it was not, upon which I was taken up and carried before the Lord Mayor. But I was discharged, because I only came with it for acceptance." He paused, and the court waited. The story was already in its outline familiar enough. A man presents a document at a bank. The bank suspects forgery. The man is detained and brought before a magistrate. This was the routine of commercial fraud in Georgian London, and everyone in the courtroom would have understood the sequence of events without difficulty. But the interesting part was what Cannon said next, when he began to explain how he came to have the note at all. "I had it from the prisoner," Cannon continued. "He came to my house, the sign of the Cannon in Suffolk Street, with 2 bailiffs, and desired me to bail him in an action for 6 guineas. I told him I did not care to be bail for him, because I had suffered before by being bail, and had paid the money. He said, 'Because you shall not be under any apprehensions of losing by me, here is a note, but the money is not yet due. Take it for your security, and I shall be obliged to you.' So I took it as a security, and had it 6 or 8 days in my pocket. It is now in the same condition as it was when I received it from the prisoner, and when I tendered it for acceptance, excepting that my name, Cannon, is wrote upon the back. I have known the prisoner 2 or 3 years, and I know his handwriting. I have seen him write several times. I take the words Lutterell and Company to be the prisoner's hand. All the note, I think, is the prisoner's handwriting, and I have seen him write several times." There it was. The wine merchant of Suffolk Street, a man who knew Rochford Fitzgerald's handwriting from having watched him write on multiple occasions over the course of their acquaintance, was telling the court that every word of the disputed draught was in Fitzgerald's own hand. This was the prosecution's central contention, that the note was forged, that Fitzgerald had written it himself, and that the evidence of a man who knew his writing well was sufficient to establish that fact beyond doubt. Now the prisoner's counsel, sitting to one side of the court, rose to cross-examine. In the 18th century, as noted, the defense counsel's role in criminal trials was limited. But one thing counsel could do was conduct cross-examination of prosecution witnesses, and this was used to considerable effect in tonight's case. The questions put to Cannon on behalf of Fitzgerald were careful and probing, designed to expose inconsistencies in his account and to suggest an alternative interpretation of the events he had described. The prisoner's counsel asked, "You speak of something on the back of the note." "What was written on the back?" Cannon answered. "When I tendered the note for acceptance, Mr. Lutterell was sent for, and he asked me my name and where I lived. I told him, and he wrote it on the back of the note. I did not examine the note when I took it, but thought it a very good one, seeing it drawn on checked paper, and I read it at the same time, and thinking it was a good note, I did not take much notice of it." This is an interesting admission, and it sits a little awkwardly with what Cannon had said earlier about recognizing Fitzgerald's handwriting. He is now saying that when he received the note, he did not examine it closely, that he thought it was a genuine instrument, and so did not scrutinize it as he might otherwise have done. The implication, which the defense would later draw out more fully, was that Cannon had received the note under the impression that it was a legitimate draft on Lutterell's account with the bankers, and that his later claim to have recognized Fitzgerald's handwriting was a retrospective interpretation coloured by what he had subsequently learned. "Did you take it to be my handwriting when you received it from me?" the prisoner asked. Cannon answered, "No, I did not. I did not know, but it might be Mr. Lutterell's handwriting." The prisoner pressed further. "Was not you acquainted with my handwriting before?" Cannon said, "Yes, but I could not then tell whether it was his or no. If I had taken it to have been the prisoner's handwriting, to be sure I should not have carried it to the bankers for acceptance." This is the heart of the contradiction in Cannon's evidence, and it is one of those moments where the trial record reveals something genuinely interesting about human memory and perception. Cannon claimed, on the one hand, that he recognized Fitzgerald's handwriting and believed all the note to be in his hand. On the other hand, he admitted that when he received the note he had not taken it for Fitzgerald's writing, that he had thought it might be Lutterell's, and that he would not have taken it to the bank at all if he had believed it to be in the prisoner's hand. Both of these things cannot be entirely true simultaneously, and the jury would have to decide which account to prefer. "Was not I arrested that morning?" the prisoner asked. "And had not I some discourse with you before this note was given you, about your being bail for me?" "Yes," Cannon said. "He was arrested that morning, and I did not choose to be bail for him. He had sent for me before this, to be bail for him for £32, which I refused. But this, he said, was a trifle, it was but for 6 guineas. Did not you say you did not care to be bail because you should disoblige your wife?" "I cannot tell whether there was any discourse at all about my wife," Cannon replied. "I never consult her about these things." "How long was it after I came in that you bailed me?" in about 8 or 10 minutes. Was the note given before you bailed me, or after? I cannot resolve that question, Cannon said. I think it was given me for a security, if I would bail him. I told him I did not care to be bail for him, and he gave me this note as a security, and said it will be the same as money. He told me it was not yet due, and therefore he could not then command the money. Did not you say you must have something to show your wife before you could give bail? I never mentioned a word about my wife when he talked about my being his bail, as I know of. I think the note was given me after I had bailed him. I was not willing to be bail for him. But when he offered me the note for a security, I agreed to be his bail. The note was then read into the record as set out in the indictment, and on the back of it was written, as Cannon had described, the words Pa, Cannon, in Suffolk Street. The prisoner's counsel continued. You say you were taken up on New Year's Day was a 12-month. When did you see me after that? The next day, Cannon said, and several times afterwards, but he was not taken up on this account. The prisoner came to me the next day after I was taken up, and asked me if I had not been in the city with Mr. Lutterell. I said, No, I have not. He replied, I thought I had seen you with him, and at that very time I sent for Mr. Mark Lorne, and told him I would not let the prisoner go until I was satisfied for the money I had bailed him for. The prisoner then said he was sorry for what he had done, but Mr. Lutterell, he said, had given him liberty to draw upon his cheques. He further told me he had been with Mr. Lutterell, and had desired him not to give the note out of his hands. Had not I surrendered myself in discharge of my bail at that time? No, Cannon said. For on Saturday after this he came to my house in the afternoon, and said he had paid the debt, or made it easy. But on the Monday following I had notice that if I did not come and pay the money, I should be sued. So I went and gave in bail above, which cost me 8 shillings. After this he gave me his sword, and 2 guineas for my security. Have not I been often at your house for these 8 months last past? And have not I been visible and public in other places? Yes, Cannon admitted. I believe he hath. Have you not declared that at the time the note was given you, you knew it was my handwriting, and that it was deposited with you only to make your wife easy? No, Cannon said. I swear I never did. This denial is firm and unequivocal, and it would be tested by other witnesses in the course of the trial. The question of what Cannon had said about the note on the day it was given, and whether he had then known it was Fitzgerald's writing, would become one of the central threads of the defence case. At this point in the proceedings, a significant legal question arose. The prosecution called Mr. Lutterell, the merchant whose name appeared on the forged draught, whose account with Knight and Shuttleworth had been used without authorization, and who was in the most direct sense the man whose identity had been appropriated. He appeared, ready to give evidence, and the prisoner's counsel immediately objected to his being sworn. The objection was this. The indictment charged the prisoner with intending to defraud the said Mr. Lutterell. That being so, Lutterell was not merely a witness, but a person whose financial interests were directly affected by the outcome of the case. If the prisoner were convicted, the fraud against Lutterell would be established, which might have consequences for Lutterell's own legal position or financial dealings. If the prisoner were acquitted, the fraud would not be established, and the document that purported to carry Lutterell's name would remain in legal limbo. Either way, Lutterell had an interest in the verdict, and under the rules of evidence as they then applied, a witness with a direct interest in the outcome could not be permitted to give evidence. The court considered the point and agreed. Mr. Lutterell was not permitted to give evidence. He was sent away without being sworn. This was a significant blow to the prosecution. Lutterell was presumably the person best placed to testify that the handwriting on the note was not his, and that he had given no authority for anyone to draw on his account in the form used. His evidence was precisely the kind of direct, first-hand testimony that a forgery prosecution needed. Without it, the prosecution had to rely on other witnesses to establish that the handwriting was not Lutterell's, and on the admissions that the prisoner himself had already made. For here is the remarkable thing. The prisoner admitted the note in question to be his own handwriting. This admission was not a confession of guilt. It was rather a very deliberate legal move. Fitzgerald did not deny that he had written the note. He was prepared to acknowledge that the document was in his hand. What he denied was the intention to defraud anyone. His defence, which he would spell out at length when his turn came to address the court, was that the note had been written as a private piece of paper, given to Cannon not as a negotiable instrument, but as a token of good faith, and that Cannon's subsequent decision to carry it to the bankers for acceptance had been made without his knowledge or consent, in direct breach of the understanding on which it had been given. It was a bold strategy, and in some ways it was the only available strategy. With a witness like Cannon prepared to say that the handwriting was Fitzgerald's, there was little point in denying authorship. The question was what the writing had meant, what had been intended by it, whether there had been the criminal intent that the law required for a conviction of forgery. The next prosecution witness was Edward Masters. He came to the stand with what appears, from the record, to have been a degree of reluctance. His evidence was damaging, but less so than the prosecution might have hoped. "I cannot positively say I heard the prisoner say he forged this note," Masters told the court, "but I advised him to go abroad on account of forging it." This is a carefully worded statement. Masters did not claim to have heard Fitzgerald confess to forgery. He said he had advised him to go abroad because of it, which implies that the matter was understood between them, that there was no denial, but that Masters could not testify to an explicit admission. It was the evidence of a man who knew what had happened without being able to say, in strict evidential terms, that he knew it. The prisoner's counsel cross-examined. "After this note was given, was not I visible and to be seen?" Masters answered, "Yes. I have seen him at Cannon's house after the note was given and after Cannon had been carried before the Lord Mayor. I cannot tell how often I have seen him there. I have met him in the streets within these 3 or 4 months, but have not seen him at Cannon's house within these 8 months last past. Formerly, I have seen him in Mr. Lutterell's company, but not since the date of this note. The prosecution counsel pressed on a different point. But when you advised him to go abroad, did he not take your advice? He went abroad some time afterward, Masters said. It was some time in the latter end of January. How long he stayed abroad I cannot tell. The question of Fitzgerald's departure for France was a thread that ran through the whole of the trial, because it was the one piece of evidence that most clearly suggested consciousness of guilt. An innocent man, the prosecution's logic implied, would not flee. He would remain in London, face the warrant, and vindicate himself before a court. The fact that Fitzgerald had gone to France, even if he later returned and lived openly in London for months, suggested that there had been a moment when he himself believed that what he had done was indefensible. The defence would have something to say about this, and we will come to it in time. The next witness was Mr. Shuttleworth, the banker. His admission to give evidence had required a brief argument, because as a partner in the firm of Knight and Shuttleworth, and therefore one of the persons allegedly intended to be defrauded by the note, his interest in the outcome was at least arguable. But the court took the view that since he had refused to accept the note when it was presented, he had no actual financial liability arising from it, and therefore no direct pecuniary interest in the verdict. He was sworn and gave his evidence. Though the note was brought to me, Shuttleworth told the court, I was not liable to pay it unless I had accepted it. I had money of Mr. Lutterell's in my hands, and had the note come from him, I should have paid it. This note was brought to me by Canon on the 1st of February 1738 for acceptance. I knew it was not Mr. Lutterell's hand, but if I had not happened to have seen it, I do not know but our servants might have accepted it. When you saw it was not Mr. Lutterell's hand, did not you give him notice? Yes, Shuttleworth said. I sent for him. Did you ever pay any draught to the prisoner in Mr. Lutterell's name? No, never in my life, as I know of. We had had several drafts forged upon us, one in particular for £154, which made me the more careful at that time. This is a detail worth noting. The banking house of Knight and Shuttleworth had been the target of forged drafts before. They had lost £154 to a previous forgery, which was a very considerable sum indeed for the period. This experience had made Shuttleworth particularly attentive to the genuineness of drafts presented for acceptance, and it was this heightened vigilance that had caused him to look more closely at the instrument Canon brought in, to send for Lutterell, and to have Canon detained when Lutterell confirmed the signature was not his. Did not Mr. Lutterell's drafts used to be in the name of Lutterell and Company? Yes, Shuttleworth said. Formerly they did, but not lately. Not when this note was made. This is a point in Fitzgerald's favour, as his own defence would later make clear. The note he had written was signed Richard Lutterell and Company. But Lutterell's drafts, by the time the note was dated, no longer used the form and company. A genuine draft from Lutterell to his bankers in December of 1738 would have been signed simply in his own name. The use of the form and company was therefore either a careless mistake by a forger who was drawing on outdated knowledge of how Lutterell's drafts were worded, or, as Fitzgerald later claimed, a deliberate addition designed to signal that the document was not what it appeared to be. Was not the note shown to Mr. Lutterell at the time it came to be accepted? Yes, it was, Shuttleworth confirmed, in order to be carried to my Lord Mayor's, and it has been either in his hands, or mine, or the attorney's ever since. We gave it to the attorney, that he might take out a warrant for the prisoner. But he was not taken up, for he fled, as I was told by Mr. Barnard, the attorney. The counsel then turned to Canon, who was still present in the court, and asked him a further question. Was you acquainted with Mr. Lutterell's handwriting, as well as the prisoner's? I cannot say I am, Canon answered. I never saw him write in my life. This admission substantially undermined Canon's claim to have recognized the handwriting. He had said with confidence that he believed the whole of the note to be in Fitzgerald's hand, and that he knew Fitzgerald's writing from having seen him write many times. But he could not compare that writing with Lutterell's, because he had never seen Lutterell write. His identification was therefore entirely based on his recognition of Fitzgerald's hand, not on any elimination of the possibility that the writing might have been Lutterell's. The prosecution's case was complete. Now Rochford Fitzgerald rose to speak in his own defence. What follows in the trial record is one of the more remarkable pieces of self-presentation to appear in the Old Bailey proceedings of this period. Fitzgerald spoke at length and with considerable coherence, laying out a detailed alternative narrative of the events in question. Whether every word of it was true is another matter, but it is the account of a man who had thought carefully about what he needed to say, and how he needed to say it, and who had the social confidence and verbal fluency to say it well. The defence began with a description of the circumstances of the arrest, designed to contrast with Canon's account, and to make Fitzgerald's version of the day seem more plausible. Canon says I came to him with 2 officers, Fitzgerald said. I had been with him to tell him that I had had the officers with me, on account of a debt which was not my own. And not being willing to pay it, I desired him, Canon, to pay it, and I appointed the officers to come to his house, and I would meet them there. Accordingly, I went thither, and drank Frontignac above stairs, and told him I had been arrested, and by whom. And I desired him to be bail for me, telling him I should have money in a few days. He made no objection to it, but said he had no kind of doubt that he should suffer by me, I having often owed him more money and paid him. So far, this version is not dramatically different from Canon's. Both accounts agree that Fitzgerald had been arrested for a debt of 6 guineas, that he had gone to Canon's house, that he had asked Canon to bail him, and that Canon had initially been reluctant. The significant divergence comes next. Afterwards he told me, Fitzgerald continued, he apprehended it might occasion some family disturbance, and begged to be excused from bailing me, unless I could contrive to silence the family disturbance. Upon which I took this piece of checked paper out of my pocket, which I had from Mr. Fitzgerald, who is Mr. Lutterell's clerk, to make some drafts upon Mr. Lutterell, by order of a gentlewoman who had cash in his hands. And upon a piece of this checked paper I wrote this draft, desiring him not to use it, and telling him I gave it him to silence the disturbance in his family, till I brought him the money, or the plaintiff's discharge. And in this confidence in him, that it should not be made use of, I gave him this draught, and made it payable not until 14 days after date. This is the crux of the defence. Fitzgerald's case was that the note had been written in Cannon's presence, on the spot, as a private accommodation, a piece of paper given not as a genuine instrument, but as a token of good faith to satisfy Cannon's domestic situation and secure the bail. He was not, he claimed, presenting it as a genuine draft on Lutterell's account. He was writing something that looked like a draft as a way of assuring Cannon that he had the resources to repay him, without actually putting a genuine instrument in his hands. But the day after, he, being pressed for money, goes into the city and offers the note. Fitzgerald continued, telling me I was a good-natured man, and he believed that as I was intimate with Mr. Lutterell, the sanction of my name would have influenced Mr. Lutterell to pay it. This is a remarkable accusation. Fitzgerald was effectively turning the tables, suggesting that Cannon was not an innocent victim who had been deceived into accepting a forged note, but a man who had knowingly taken a piece of paper that he knew to be Fitzgerald's own writing, and attempted to pass it off at the bank in the hope that the connection between Fitzgerald and Lutterell would cause the bankers to honour it without looking too closely. What I have further to offer, Fitzgerald went on, is that I had at that time several accepted notes of Mr. Lutterell's in my possession, and therefore it is not to be supposed that I should do this with an intent to defraud him. And I put the word company to his name, lest it should be made an ill use of. The first part of this argument was that a man who had genuine instruments from Lutterell in his pocket had no need to forge one. If he had authentic drafts of Lutterell's that he could have used, why would he go to the trouble of forging one? The second part returned to the question of the added words and company, which Fitzgerald now explained explicitly as a deliberate precaution, a way of introducing an error into the document so that it could not be presented as a genuine instrument. Mr. Lutterell told me, Fitzgerald continued, being married to one of his family, and being often at his house and seeing his letters and being conversant in his counting-house and in his business, that he was assured I did neither intend nor mean to injure him or Mr. Shuttleworth, but that I had done an imprudent thing. Therefore, says he, go and discharge Cannon from any demand he has upon you. Accordingly, though I never intended to have paid this debt of £6, yet as I had done so imprudent a thing, I went and paid it. And yet after all this, Fitzgerald concluded, Cannon, being spirited up by some people who are pleased to have some little jealousy of me, goes before Colonel de Vale and makes an affidavit of all this, upon which there was a warrant taken out against me, and I was advised to step out of the way. I refused to go at first, because that would look like guilt. But afterwards, having £157 due to me at Dunkirk, I applied to Mr. George Fitzgerald in the city, and he gave me a letter of recommendation that I might be assisted in the recovery of the debt. And having a gentlewoman that lived with me at that time there, I promised to come see her at Dunkirk, for which end I sent over some money and clothes, and went to her, because some of her friends and mine were disobliged at our living together. So I took that opportunity to go thither. and an affair about a bankruptcy detained me there longer than I intended to stay. But since my coming back, Fitzgerald said, I have been several times at Mr. Lutterell's and 50 times at Cannon's house, and I have dined there often. I imputed this transaction to his ignorance rather than to any design. But being there one Sunday evening playing a game at cards, Cannon, who served the wine, was pleased to make some observations on the game, which since has subjected me to another indictment. He alleging that I subjected the gentleman, my partner, to the loss of the game, that I might come in for a share of his money which he was to lose. I intended to have prosecuted Cannon for this aspersion, and so he brought this prosecution against me. It is a remarkable speech. It contains, in roughly equal measure, plausible explanation, self-serving embellishment, and a counter-attack that reframes the entire prosecution as a vindictive act by a man who had other reasons to be angry with the defendant. Whether the jury believed it, we shall come to in due course. But first, the witnesses for the defence were called. After Fitzgerald had delivered his statement, Mr. Shuttleworth was asked a further question. Did he give this checked paper to people that were to draw upon him? Shuttleworth answered yes, and said that he believed the cheque upon which the forged note was drawn was indeed one of his. This was a significant concession. If the checked paper was of the kind distributed by the banking house to its clients for use in drawing orders, and if Fitzgerald had genuinely obtained it from Lutterell's clerk in connection with some legitimate business, then his claim to have had it innocently in his possession gained some plausibility. Now the defence witnesses were called, and their testimony built up a picture of events that both corroborated some of what Fitzgerald had said and complicated it in ways that were not entirely comfortable for either side. The first defence witness was Robert Gill. He was one of the officers, the bailiffs, who had arrested Fitzgerald on the December morning in question, and he had been present at Cannon's house when the bail was given. I and Matthias Powell arrested Fitzgerald, Gill told the court, in St. Martin Street near Leicester Fields. Sometime in December last was a 12-month. He was carried to the Pied Bull in Gray's Inn Lane, and afterwards to Cannon's house. There was nobody with us at Cannon's but Powell and I, the prisoner, and Powell's man. We went upstairs, and I was one of his bail with Cannon. I do not remember any talk about the note, nor did I see any note given. Cannon had been applied to before to bail the prisoner in an action in the sheriff's court for £30, but his bail was not thought sufficient at that time. In this action for 6 guineas, Robert Fitzgerald was plaintiff, and the suit was in the Marshalsea court. And when the prisoner proposed Cannon to be his bail, he said he did not want any security at all. He said nothing about this note. I did not see anything of it, nor was there anything said about Cannon's wife. Where did you first see Cannon? The counsel asked. At the Pied Bull in Gray's Inn Lane, Gill said. Fitzgerald and Cannon were together there, and I went with them from thence to Cannon's house. Might not the prisoner and Cannon be together when you were not present? I was not with them all the time, Gill admitted, for we stayed at Fitzgerald's lodgings while he went to see for bail. How soon was the bail given after you came to Cannon's house? It was given directly, as soon as possibly it could be done. What did Cannon say when I asked him to be bail for me for the 6 guineas? The prisoner asked. Fitzgerald put his hand in his pocket, Gill said, and pulled out some money. Cannon said he did not want money at all. His honour was sufficient. This was just before he gave bail. This is an interesting detail. Gill's recollection was that Cannon had explicitly declined any offer of money or security before agreeing to give bail. If this is accurate, it is inconsistent with the story that a note was given as a security to persuade Cannon to act as bail. But Gill also admitted that he had not been with Cannon and Fitzgerald the entire time, that there had been a period when they were elsewhere together. And it is during that period that the note, if it was given at all, might have changed hands. The next witness was Mark Lorne. Lorne was a Marshalsea court officer, one of those men who made their living executing the legal process of the debtors' court, and he had been at Cannon's house on the morning in question in connection with some other business. "I went to Cannon's house when the prisoner was arrested," Lorne told the court. "Cannon told me Fitzgerald was arrested for 6 guineas and was above stairs with 2 officers. Before I went away, Cannon went upstairs, and when he came down again, he told me he had bailed him, and he had a note in his hand. I looked at it and said it was a draught on Messrs. Knight and Shuttleworth. 'No,' says Cannon, 'it is his own handwriting.' 'Why,' says I, 'do you think the man would be such a fool to do such a thing?' Cannon immediately put his hand in his pocket and pulled out a letter, which he said was his handwriting too. I laughed at him and said it was a joke. I told him it was a good note on Messrs. Knight and Shuttleworth. 'No,' said he, 'it is his own handwriting. I know it as well as I do my own.' I insisted upon it that no man in his senses would do such a thing, upon which he put his hand in his pocket and pulled out the letter. I compared the note and the letter, and never saw 2 things so much alike in my life. And then I believed it. This was 5 or 10 minutes, or a quarter of an hour, before the officers went out of the house. When he showed me the note, he said to me, 'I would have bailed the prisoner had he given me nothing. But he gave me this, and I know it is his handwriting.'" This testimony from Mark Lorne was important to the defence for 2 reasons. First, it established that Cannon himself had told someone on the very day the note was given that he would have bailed the prisoner for nothing, which undermined the prosecution's implication that the note had been given as a necessary inducement. Second, it established that Cannon had from the outset believed the note to be in Fitzgerald's own hand, which made his subsequent claim to have taken it at face value as a genuine draught on Lutterell's account look rather less credible. "Did he give you no reason why he took the note, when he said he would have bailed me for nothing?" the prisoner asked. "No," Lorne said. "He did not. I might think what I pleased, but he said nothing to me about his wife. I never saw the prisoner above once or twice before he came to Cannon's to be bailed. I thought it was done to satisfy his wife, as such things are often done to make a family easy. But he did not say anything about his wife." "And would you see a false note produced under a gentleman's hand, and not complain of the fraud?" the prosecution counsel asked. "Am I to be busy and complain?" Lorne replied. "When the man, Cannon, told me himself that he knew it was Fitzgerald's own writing, I think I should have done very ill if I had told of it in any company. I was glad to see Fitzgerald out of custody." "Where did you learn such principles?" "Of Rietbok?" the counsel demanded, in what sounds very much like a personal taunt, a reference to some figure known to the court but not explained in the record. "I knew Mr. Rietbok," Lorne answered, evidently untroubled by the question. "But what is that to me?" "Since the prisoner came from France," Lorne continued, "I have been in his company, and have seen Cannon with him. And so I have after Cannon had been taken up about this note. I was with him when he left his sword and 2 guineas with him as a security for the 6 guineas after the note was discovered. It was easy for him to have taken him up before he did, for after he came from France, he appeared as publicly as any man in the world. I have seen him at Randall's Coffee House, and at the Royal Exchange, Fleet Street, and all parts of the town." The prisoner then asked Lorne whether Mrs. Cannon had come into the room at the time he was showing the draught, and saying it was his handwriting. "I think that was the thing that stopped our discourse," Lorne said. "I cannot remember particularly whether she came into the room, but when the door was open, she might hear every word we spoke. I think I saw her, and that hushed our discourse. This is a vivid detail. The suggestion is that the comparison of the note with Fitzgerald's letter, and Cannon's open acknowledgment that he knew it was Fitzgerald's own writing, had been interrupted by the appearance of Mrs. Cannon in the doorway, at which point Cannon had quickly put the papers aside. If this is accurate, it supports the defence contention that Cannon had known from the start that the note was not a genuine draft, and had suppressed that knowledge when dealing with the bankers. The next witness was Constantine Matthews, who had also been at Cannon's house that morning in the company of Mark Lorne. His evidence largely confirmed what Lorne had said. "I was with Mark Lorne at Cannon's house the day the prisoner was bailed," Matthews told the court. "When Cannon came downstairs, he said he had bailed the prisoner, and he brought down the note, and said it was his handwriting. And he took a letter out of his pocket, and compared it with the note. I did not know the prisoner's handwriting, nor did Cannon say on what account the note was given him. Mrs. Cannon was passing to and fro at the same time," Matthews continued, "and she came into the room when he was comparing the note with the letter, upon which he put it aside. And when she was gone, he compared them again. Mr. Lorne compared them together likewise, and said he knew it was his handwriting upon comparing the names together." "Did he say the names, or the body of the note was the prisoner's writing?" the prosecution asked. "I do not know what a note is," Matthews said simply. "But he compared the handwritings together and said they were the same. I am Lorne's assistant, and have been at Cannon's many times." Then came John Cogland, who told the court that he used to go to Cannon's house to drink a glass of wine, and that about 18 months ago he had heard Cannon say there was a draft of £12 10 shillings, and that he was sorry he had presented it, for fear it should hurt the prisoner. There was an intimacy between the prisoner and Cannon after he had presented the note, Coglan said, and Cannon had said he believed it was not the prisoner's intention to defraud anybody by it. This is perhaps the single most important piece of evidence for the defence. It was Cannon himself, according to Cogland, who had expressed regret at having presented the note, and had attributed no fraudulent intention to Fitzgerald. If this is accurate, it tells us that Cannon's own understanding of the matter, long before this prosecution was brought, was that Fitzgerald had not meant to defraud anyone, that the note had been some kind of private arrangement gone wrong, rather than a deliberate attempt to obtain money by deception. Now came the testimony of Robert Fitzgerald, who shared the defendant's surname and appears to have been a relation, the plaintiff in the original debt action for 6 guineas that had led to the arrest. His evidence was long and detailed, and cut in several directions at once. "I know the prisoner," Robert Fitzgerald told the court, "and have seen Cannon once or twice. This note was given him about 18 months ago, but I have seen him and the prisoner in company together after that. Fitzgerald the prisoner owing me 6 guineas upon a note, I got him arrested, and my attorney told me he had put in bail. A fortnight afterwards, the attorney told me that unless the prisoner surrendered, the bail would be fixed for the money. About a fortnight after this, the prisoner called at my house and proposed to pay me 5 guineas. I went with him to a tavern, and there I saw Mr. Masters, a wine merchant, and Mr. Cannon. And I received 5 guineas, 4 of which Cannon gave to the prisoner, and he, the prisoner, adding 1 to it, gave it me. And he was to pay the attorney. At the same time, Cannon returned a silver-hilted sword to the prisoner, and the bail was discharged upon the prisoners, giving me a note for the remaining guinea. Mr. Masters told me the prisoner had made a fine job of it, for in order to get bail to my action, he had forged Mr. Lutterell's name to a draught upon the bankers. Why, says I, what were the 4 guineas and the sword for? The prisoner said he gave him them to induce him to be bail for him, and Cannon was by and seemed to own it. But he made some difficulty in giving back the 4 guineas, because the prisoner owed him 35 shillings for wine and reckonings unpaid. I asked the prisoner how he could do so imprudent an act as to sign a man's name to a note. Robert Fitzgerald continued. He told me he did it to let Cannon see he did not want money, for he intended to make up the 4 guineas which he had given Cannon to 6, and to have paid me. But Cannon's calling at the bankers with the note had discovered it to be bad. Did Cannon hear the prisoner say he had deposited 4 guineas with him to induce him to be bail? The prosecution asked. Yes, Robert Fitzgerald said, and Cannon owned it. And with relation to the 30 shillings which Cannon would have stopped, the prisoner told him he need not talk so much about 30 shillings for his reckonings, for he had made his wife a present of something of much greater value. I thought it was an odd way of reproaching Cannon with his own gallantries, but I was very glad to get my 5 guineas. I have heard the prisoner's defence, Robert Fitzgerald continued, and that he says he gave Cannon this note to pacify his wife. But I heard nothing of such a pretence then. I asked the prisoner what need he had to give him a note when he had left 4 guineas and his sword with him. He told me he did it because he would not have him think he was under any obligation to him. I understood that the prisoner drew this note before Cannon's face, and I told Cannon he was a fool to take a note wrote before his face. Mr. Masters said something, that Cannon was a blockhead. But I do not know whether Cannon was in the room when this was said. I was there about 10 minutes, or much about that space of time. And the prisoner then insinuated as if Cannon had seen him draw the note. I have seen Cannon once since that time at Mr. Lutterell's, Robert Fitzgerald added, and it was the day after the masquerade. He insisted upon it that the prisoner took it out of his pocket ready drawn. And if he has sworn so now, I do not doubt but it is true. This last sentence is notable. Robert Fitzgerald, who had initially repeated the prisoner's own account that the note had been written in Cannon's presence, was now saying that Cannon's version, in which the note was produced from the prisoner's pocket already written, was probably the more truthful one. It is the honest admission of a witness who had heard two conflicting accounts and found himself unable to choose between them, but who ended by giving the benefit of the doubt to the man who had been most directly affected. Then came Mr. James Barrett, who deposed that he knew the prisoner, and that at Mr. George Fitzgerald's request he had given Fitzgerald a letter of recommendation to a friend at Dunkirk in October, that the prisoner might be assisted in the recovery of a debt. A month or two afterwards he had seen the prisoner upon change, and had frequently seen him since he returned from France. The witness was asked whether the debts he had gone to recover were not a Nelson, a jeweller's. He answered he could not tell. A witness identified only as J.H. gave evidence that he had known the prisoner for 5, 6, or 7 years, that he had lived as a servant with a neighbour of his, that his master had given him a good character when he left, and that since then the witness had bought goods from him, given him credit, and been paid. He was asked whether he had not suspected the prisoner of taking some of his goods, and he answered that someone had said something to him about a piece of cambric, but that he was convinced there was nothing in it. James Leone had known the prisoner about 4 or 5 months, and had been in his company several times, but knew nothing of his general character. The witness added nothing of particular weight to the proceedings. A witness identified as G.B. had known the prisoner for 7 or 8 years, and had had transactions with him, never meeting with any fraud. He had seen the prisoner at his house, though he had never had any conversation with him at taverns or public houses. He believed the prisoner had been a visible man for 7 or 8 months last past. He had known the prisoner before he went to France, and while the prisoner was there, he had transacted some affairs for him relating to a man named Nelson, and the witness had sent him a bill of £20 for his trouble. Henry Bostock offered what was perhaps the most candid and least comfortable character evidence in the whole trial. He had known the prisoner some years, and he was surprised, he said, that the prisoner should have subpoenaed him in his behalf when he could speak nothing in his praise. The prisoner's general character for 5 or 6 years past, Bostock said, was such that he should be ashamed to claim him for an acquaintance. He understood him, in general, to have an idle and contemptible character. He knew nothing wicked of him himself, but he knew nothing good either. James Cogland had known the prisoner about 6 years, and had never until now heard of his being dishonest. Joseph Simmons had known him 8 years, and had never heard anything ill of him, except that he was addicted to gaming. Alexander Montgomery had known him since 1728. He had used the witness's house, and they had had dealings together. He had never known anything amiss of him, but had heard he was under misfortunes about the year 1738, and had gone abroad. After which he had returned, and was frequently at the witness's house, and had been visible within 8 or 10 months last past. A witness named Burgess had known the prisoner about a year, in which time he had never heard any great harm of him until now. His first acquaintance with the prisoner had been in France. Edward Fitzgerald, who was Mr. Lutterell's bookkeeper, and no near relation to the prisoner despite the shared name, gave evidence that the prisoner and his master were acquainted, but had no dealings together as he knew of, except that sometimes Mr. Lutterell used to give the prisoner a draught on Messrs. Knight and Shuttleworth, for money due to a Mrs. Rooks, who received an annuity of £50 per annum from Mr. Lutterell. Sometimes the prisoner came for the money, sometimes Mrs. Rooks. And Mrs. Rooks and the prisoner kept company together, though the witness did not take them to be man and wife. He further said that he had delivered 2 or 3 of Mr. Lutterell's cheques to the prisoner, because the prisoner had told him he wanted to go to the play, and he gave him these that he might write upon them to the box-keeper, in order to get admission for himself or his friends. This last detail is extraordinary. If Edward Fitzgerald's evidence is to be believed, the prisoner had on multiple occasions legitimately obtained pieces of Lutterell's checked paper from the counting-house, ostensibly for the purpose of writing notes of introduction to theatre box-keepers. This was presumably the kind of thing that passed as a courtesy between a wealthy man and the people in his social circle, a note on his distinctive checked paper being a kind of informal guarantee of respectability. But it also meant that Fitzgerald had a legitimate explanation for being in possession of such paper, and that his claim to have obtained it through proper channels was not obviously false. A further witness, Rob Fitzgerald, deposed that upon the prisoner's application to him to give him a character, he had sent the prisoner word that he could not do it. He swore the prisoner's character was very indifferent, and that ever since he had quitted business for a pleasurable life, he had been a gamester. He added that he had heard of 20 bad actions of the prisoner's, such as he should have been ashamed of. Then came another gentleman who deposed that he had never had any acquaintance with the prisoner, but that he had heard him called a gamester and a sharper. And with that, the evidence was complete. The lawyers spoke, the jury listened, and then they retired to consider their verdict. They were not long. Georgian juries were not in the habit of extended deliberation. The culture of the time did not encourage the kind of prolonged collective examination of evidence that we now associate with the jury's function, the going back over every witness's words, the careful construction of timelines, the weighing of contradictions. The 12 men who had sat through the evidence in the case of Rochford Fitzgerald would have known, as they retired, what the essential question was. It was not really a question about handwriting, or about whether the note had been written by the defendant. He had admitted that himself, The question was about intention. Had Fitzgerald written that document with the intention of defrauding someone? Or had he written it as a private accommodation, a token given in confidence to a man he trusted, never intended to be presented at a bank? And perhaps there was another question underneath that one. A harder, quieter question. The kind that does not appear in the formal record, but that 12 ordinary men sitting together would have felt in the room with them. What kind of man was this? Was he the sort of man who would do such a thing? Was he the sort of man who could be trusted to tell the truth about his own motives, even when those motives were at best embarrassing and at worst criminal? The character evidence had been mixed, as character evidence in this period often was. A collection of men who knew Rochford Fitzgerald had come to court, and the picture they had painted was not a flattering one. Idle, contemptible, a gamester, a sharper. These were damaging words, and they came from men who had been subpoenaed to speak in his behalf. A man who had to face the prospect of his own character. Witnesses calling him contemptible is a man whose reputation has fallen a long way. And yet none of them had spoken of any specific dishonesty in their own dealings with him. None of them had said he had cheated them in business, or failed to pay a debt, or committed any definite fraud. The worst that could be said by people who actually knew him was that he had given up honest employment for a life of cards and pleasure, which was a moral failing rather than a criminal one. The question of the note itself remained genuinely ambiguous, and it is to the jury's credit, if we are being generous, that they took the ambiguity seriously. Cannon's evidence had been undermined by his own contradictions. He had told the court he had recognized Fitzgerald's handwriting, and also that he had not recognized it. He had said the note was given as a security, and also that he would have bailed the prisoner for nothing. Mark Lorne had testified to Cannon's own words on the morning of the arrest, words that suggested Cannon had never been deceived at all, had known from the first that the document was in Fitzgerald's own hand, and had taken it as a private accommodation before deciding later to present it at the bank. And John Cogland had told them that Cannon himself had regretted doing so, had expressed sympathy with the prisoner, and had said he did not believe Fitzgerald had intended to defraud anyone. Against all of this, the prosecution had the evidence of Mr. Shuttleworth, whose testimony was credible and uncontradicted. He had seen a forged instrument. He had refused to accept it. He had detained the man who brought it. He had sent for Lutterell, who had confirmed the signature was not his. These were facts that nobody disputed. The question was what they added up to, and in whose hands the guilt for them lay. The jury came back. The verdict was delivered. Not guilty. Rochford Fitzgerald was acquitted. He walked out of the Old Bailey on that May morning in 1740, a free man, the forgery charge having failed to persuade 12 of his fellow subjects that he had acted with criminal intent. Whatever one thinks of the justice of this outcome, it was a genuine acquittal, arrived at by a jury who had heard all of the evidence and weighed it carefully enough to conclude that the prosecution had not made its case. What happened to him afterwards, the record does not say in any detail. The trial is the last entry in the formal public record of his affairs, at least as they touch the criminal law. He disappears back into the undocumented texture of Georgian London life, which is where most people lived and where most stories end. Whether he continued his career of social charm and financial improvisation, whether he eventually found some more stable footing in the world, whether he reconciled properly with the various people whose patience he had tested so thoroughly over the preceding 2 years, none of this is recorded. Cannon remained in Suffolk Street. Whether the intimacy between him and Fitzgerald that had apparently survived even the discovery of the forged note and the presentation of it at the bank outlasted the trial is another thing we cannot know. The curious detail that Fitzgerald had been a regular visitor to Cannon's house even after all of this, that they had played cards together on the evening that led to yet another indictment, suggests that the two men were bound together by something more durable than mutual trust and respect, perhaps simply by the ordinary adhesiveness of neighbourhood and acquaintance. The way that people who know each other in a city tend to keep on knowing each other long after the most rational grounds for the association have passed. Knight and Shuttleworth continued in their premises in Change Alley. The banking house had survived the forgery of £154 on a previous occasion, and had survived this one as well, the latter at no cost to themselves, since Shuttleworth had refused acceptance, and no money had changed hands. The care that Shuttleworth had taken, his willingness to look closely at a document that might otherwise have passed through the hands of his servants without examination, had protected his firm and had in a sense set the whole subsequent chain of events in motion. Without his vigilance, Cannon would never have been detained, the matter would never have come to the Lord Mayor, and Fitzgerald would have had £12 and 10 shillings more in the world, and a rather simpler future. Richard Lutterell, the man whose name appeared on the disputed draught, and who had been prevented from giving evidence by the rule against interested witnesses, returned to his counting-house and his regular business. His connection to Fitzgerald remained, apparently, intact. The bookkeeper, Edward Fitzgerald, had testified that the prisoner continued to visit Lutterell after all this had happened, and that when Fitzgerald returned from France, Lutterell had apparently received him without any particular coldness. Whether this was genuine forgiveness, social courtesy, or simply the resilience of a relationship that had deep enough roots to survive such an episode, we cannot say with confidence. The city outside the court went on as it always had. The coaches rattled over the cobblestones. The river moved under its bridges. The market cries floated up from Cheapside and the Strand. In the taverns and coffee-houses, in the counting-houses and banking parlours, in the pleasure gardens and the gaming rooms, the business of Georgian London continued without interruption, indifferent to the small legal drama that had just concluded within the walls of the Old Bailey. This was the world that made Rochford Fitzgerald, and that outlasted him. A world of paper and trust, and the movement of money through the hands of people who knew each other or claimed to. A world in which a man's name on a piece of paper was both his most valuable asset and his most vulnerable one. A world in which the line between a private accommodation and a criminal deception was sometimes vanishingly thin, and where the intention with which a piece of paper changed hands could mean the difference between walking free and walking to the gallows. It is worth pausing at the end of this story to notice what it does not contain. There is no dramatic confrontation. There is no smoking pistol, no body in the road, no single moment at which the truth becomes unmistakable. There is instead a tangle of overlapping accounts, of things said and not said, of what Cannon knew and when he knew it, of whether Fitzgerald wrote the note in Cannon's presence or arrived with it already written in his pocket. The truth of what happened in that room above the tavern in Suffolk Street on a December morning in 1738 is not something that can be recovered now. And it was not something the jury in May of 1740 could recover either. What they could say was that the prosecution had not proved its case beyond the standard the law required, and that was enough. In a capital case, it was everything. The evening is drawing in. The candles we lit at the beginning of this story are burning lower now. The city outside these imagined windows is quieter than it was. The last of the coaches has gone past. The watchman has called the hour. Somewhere in the direction of the river, a church clock strikes, and its note hangs in the cold air for a moment, before dissolving into the general silence of the night. We have been in 1740 for a while now, you and I. We have sat in the Old Bailey and heard the witnesses give their evidence, and watched the jury retire and come back. We have followed Rochford Fitzgerald through the streets of the city, and into the court and out of it again, acquitted and free, stepping back into the life that was waiting for him on the other side of the great oak door. Now it is time to leave all of that behind. It was a long time ago. The people in this story have been gone for nearly 300 years, their faces unknown, their voices preserved only in the compressed and paraphrased record of the court. A few lines of print on pages that have survived where the people themselves have not. We do not know what Fitzgerald's face looked like, or how he walked, or what he said when he stepped out of the Old Bailey and found himself under the open sky of Newgate Street on a May morning, with the forgery charge behind him and the rest of his life ahead. We know only what the record chose to preserve, which is always a partial and imperfect thing. But it is something. It is more than nothing. The fact that this trial happened, that these men stood in a room and made these arguments, and that a jury of 12 decided this outcome, and that someone was there to write it all down, means that on a quiet night 2.5 centuries later, it is still possible to sit with the story and feel the weight of it. The weight of a £12 10-shilling note. The weight of a man's name on a piece of checked paper. The weight of the decision that has to be made in the space between what a person does and what they mean by it. Let all of that settle now. Let it drift down like dust in a room where no one has been for a very long time. The court is empty. The candles are out. The jury has gone home to their families and their beds, and the judge has removed his wig and is sitting by a fire somewhere, thinking about something else entirely. You are here, in the present, in wherever you are, in whatever room, in whatever country, at whatever hour of the day or night. The bed is comfortable. The air is the right temperature. There is nothing that needs your attention right now, nothing that cannot wait until morning or afternoon, or whenever the next part of your life begins. Let your breathing slow a little more. Let the weight of the day distribute itself evenly through the mattress beneath you, the chair that holds you, the floor that holds the chair, the earth that holds everything. You are held. You are safe. The old city is very far away. Rochford Fitzgerald is free. Cannon is back at his tavern. Shuttleworth is back in Change Alley. The Thames is moving south and east toward the sea, as it has always moved, as it will always move, carrying the city's reflections in its dark surface, carrying everything down to the water and the distance and the dark. Sleep well, wherever you are. The night is long enough for all of it. There is something in the texture of these old cases that rewards a slow return. If you have been listening tonight and found yourself drifting in and out, half in the present and half somewhere in the fog of the story, that is exactly as it should be. These tales were not made for close attention. They were made for the half-conscious state, the place between knowing and not knowing, where the mind accepts the shapes of things without demanding that they resolve themselves into certainties. And the shape of tonight's story is a good one for that purpose. It is unresolved. It does not end with a hanging or a transportation, with the neat moral closure that the law sometimes provides, and that perhaps the listener secretly hopes for. It ends with an acquittal, with a man walking out of a courtroom into a day that had every chance of going very differently. The law did what the law was meant to do. It listened to the evidence. It weighed the uncertainty. And in the weighing, it found that the evidence was not enough. Whether Rochford Fitzgerald deserved to be acquitted is a question for philosophers and not for courts, and not for you tonight. Tonight, the question is nothing more complicated than whether the sound of these old voices, gathered from the dusty records of a city that no longer exists in quite the form it had, has been enough to carry you a little distance from the day you have had, and the thoughts that were with you when you lay down. I hope it has. I hope the long description of the Thames at night, and the cheque paper, and the counting house, and the tavern in Suffolk Street, and the patient back and forth of £12, 10 shilling notes, and sword hilts, and 4 guineas, and 30 shillings for unpaid wine reckonings, has built up enough of a quiet, purposeless weight in the mind to make sleep seem like the most natural thing in the world. Because sleep is the most natural thing in the world. Your body knows this. Your body has been waiting for this moment since before you were born. The particular heaviness that comes when the day is done and the mind is ready to let go. All you have to do is let it happen. The City of London in 1740 is very still tonight. The watchman has gone around his last circuit of the evening. The last tavern has put out its lights. In Change Alley, the banking house is dark, its doors locked, its ledgers closed, the checked paper locked away in its proper drawer. In Suffolk Street, the sign of the cannon swings faintly in the night air, but the house behind it is quiet. Patrick Cannon is asleep in his bed, Mrs. Cannon beside him, the question of the forged note resolved as well as it is ever going to be. Mr. Shuttleworth is asleep in his house near the city, his firm's money safe. Mr. Lutterell is asleep somewhere in the west end of town, his name cleared in the only court that mattered, the court where the jury came back and said not guilty, and meant it. And somewhere, in some lodging in St. Martin's in the Fields, or somewhere else entirely, a man named Rochford Fitzgerald is also asleep, having spent the day in a way that he will not easily forget, and perhaps thinking, in the moment before sleep took him, that the imprudent things we do in moments of difficulty have a way of following us for a very long time, and that the best we can hope for, when they finally catch up with us, is a fair hearing and an honest jury. He got those. Tonight, that is enough. The candle is out. The room is dark. The city breathes in the darkness, slow and deep. Somewhere beneath all of it, the river moves, as it has always moved, south and east toward the sea. Sleep now. Everything else can wait.